be seated. Your argument in 23-388, Sanders versus Boeing Co.
Hey, please the court. Mr. Davis will present argument for the appellants. Appellants have reserved 5 minutes for rebuttal.
Mr. Chief Justice, Associate Justices, and may it please the court. My name is Joshua Davis for Sanders. Certainly plaintiff petitioners come here and a common theme is salvation. But today I come armed with the savings statute, section 16064. So we can talk about it explicitly. There are 3 reasons why the court should answer the first question concerning, wrong court in appellant's favor. The first, there's no statutory requirement that there be a wrong court finding. The second, that the majority of courts of appeals and the Fifth Circuit have answered in appellant's favor. And the third, that the wrong court requirement would necessarily give jurists authority over the application of the savings statute. If a jurist can determine a lack of jurisdiction that wasn't, and the savings statute provides no remedy, then a without prejudice finding after limitations becomes dispositive, necessarily a sanction.
I think the wrong court argument is really shorthand for saying the savings statute requires the dismissal to be because of a lack of jurisdiction, and I think the argument is this really wasn't because of a lack of jurisdiction, it was really because of a pleading defect. And so the savings statute doesn't apply. And what's your best argument for why that argument is wrong?
Well, because it necessarily means that it does, that it include wrong court within the statute. So as you read the statute, the initial provision, section A, says you file in a trial court and then you file the same case in a second court. And then the subsection 1, which appellees recall or in their briefing argue, say first court, it's a reflection of the reference to the second court in the opening provision. But there's nothing in the language of the statute that says lack of jurisdiction has to be truly dispositive, legally correct. And it doesn't say a lack of jurisdiction, it says the lack of jurisdiction in that particular subsection.
Could you refile in the Northern District of Texas?
Yes, it's a proper court of jurisdiction. I mean, the refiling provision doesn't state anything with respect to where it must be. And the whole issue here, the record reflects it. It's a true statement that the parties have always been totally diverse. When we filed, and it's in, the first 10 pages of the record, the second paragraph identifies that the parties are citizens of different states. And it is a matter of controversy in excess of $75,000, invoking federal court jurisdiction. And why? Because we had a lot of discovery to do quickly on an out-of-state corporate defendant.
In the absence of a challenge to the federal court's jurisdiction, could the federal court sua sponte have dismissed the case for pleading defect if it hadn't been called to the attention of the district court?
Under Rule 41, Federal Rule 41, it can. But in doing so, it can only do it without prejudice sua sponte. In this case, it was, quote, without prejudice, but because statute of limitations run, it's necessarily prejudicial. And so as a consequence, we're here. The arguments over Rule 41 weren't reached in the underlying case. And so we briefed heavily, the consequence being a sanction. That is no relief for these plaintiffs when they timely filed, timely served, conducted discovery with the defendants on third parties for 20 months before a sua sponte order saying your pleading is insufficient. And yet you read the pleading and it identifies different citizenship and residencies in different states and corporate defendants that are out-of-state corporate defendants. And so the argument about wrong court takes the legislature's control over this exception to a limitations provision, statute by nature, and saying via a statute you can be saved. But if we take Appellee's reading and the first opinion and the Northern District's opinion, excuse me, and we allow for lack of jurisdiction to be dispositive on this issue, that is, it must be true, there must truly be a lack of jurisdiction rather than just a mistake, then there is no benefit to the statute that the legislature enacted to save cases in the face of a plaintiff who has timely brought their case in the court of proper jurisdiction, but for a mistake about jurisdiction.
It looks like two things were operating. The defendants in the case pointed out that there were jurisdictional, at the time at least anyway, they pointed out that there were jurisdictional defects in the pleadings, such that, it could call into question the district court's jurisdiction. And then there's the trial judges or the district judges' sua sponte order, and it's just trying to determine whether that is linked back to the challenge to the jurisdictional defects in the pleadings, or is it more like a 41B dismissal for failure to properly prosecute, which also would be without prejudice. And I don't know if anybody raised 41B or...
That was specifically referenced by the district court's order.
But neither party, because the order came, but neither party had sought dismissal for failure to properly prosecute.
And Justice Bland, recognizing that the record presented by the Fifth Circuit is just a fraction of the actual record and the pleadings within that record, no parties contested paragraph 2 of plaintiff's complaint. That is the diversity of citizenships. The arguments that were made concerning jurisdiction were not related to diversity. And so when we say and have said repeatedly there was no argument save for the Northern District's sua sponte order on the question of diversity, no parties were questioning complete diversity amongst themselves or between themselves for purposes of establishing federal jurisdiction over the matter. And so, and yes, absolutely.
What difference does it make if the parties were disputing?
Only to Justice Bland's point about Rule 41, that it's a sua sponte order. Nobody was asking for this. It was just the Northern District.
The judge doesn't want to proceed if he doesn't have jurisdiction.
Sure, and I think this goes to kind of Bale and Griffin and a handful of other cases where if the court adopts Appellee's reading and the reading that is argued for, all of those cases in which federal court jurists simply say no thank you, lack of diversity, or excuse me, no thank you, lack of subject matter jurisdiction for whatever reason, and then that ends up being wrong legally, those litigants are without the benefit of the saving statute, which is to be broadly read for that purpose.
Why would they need it? Because if he's wrong, you get it fixed on appeal. But he wasn't wrong.
Well, Your Honor, respectfully, I think that Fifth Circuit opinion in Sanders 1, it's a memorandum opinion, and there's a lot missing there. But again, I think that Justice Hoyt's opinion in his dismissal from the Southern District clearly identifies, no, these parties are in fact totally diverse, and there is subject matter and personal
Is it the true rule for federal jurisdiction that federal courts do not have jurisdiction until the party invoking federal jurisdiction proves it?
Well, Your Honor, I think that they have.
Is that a correct rule or not? I think it's a correct rule. Do you disagree with it?
I think that federal courts have jurisdiction when they say they have jurisdiction. That's what I think.
That can't be right. They often are reversed for lack of jurisdiction.
By other federal courts, perhaps, but that's because they're saying they don't have jurisdiction. I mean, I think that it's tautological, that the question leads to a tautological answer.
Certainly, a court of limited jurisdiction. State courts are courts, can't be courts of general jurisdiction.
Agreed.
A court of limited jurisdiction has no jurisdiction to proceed until the party invoking it proves that that limited jurisdiction actually applies. To do that in a diversity case, you have to do the very things that Judge Starr spelled out in excruciating detail saying, just fill in these blanks. Here are the things to tell me. If you do it, we can proceed. If not, I don't have jurisdiction because I'm a court of limited jurisdiction. Is any of that wrong?
Only to the extent that issuing an order sua sponte that prohibits permanently these plaintiffs pursuing their claims that were timely filed and pursued for over 20 months. And because the issue is, as much as the order is detailed, and I'll confess, misunderstanding, failure on the part of counsel, it does not matter to me for this purpose.
Matters to me a little bit because the district judge wasn't playing any games. He literally said, this is what has to happen.
In the
So
legislature,
it looks to me as though your friends on the other side have not invoked 16.064B, but I kind of wonder why, when a judge says, in order to properly invoke jurisdiction, you must do these three objective things, and someone files something and doesn't do those objective things, how that cannot be regarded as a matter of law as intentional disregard of proper jurisdiction.
I don't think anybody said or suggested that this was about gamesmanship on the part of the plaintiff.
I didn't say
Well,
gamesmanship. I don't know that
that's
intentional disregard necessarily can certainly be gamesmanship, but you have an intentional filing of something that's in disregard of express and objectively enumerated jurisdictional requirements. Now, I agree that you may be saved because from that particular acts, because I don't think that the other side has chosen to wield it. But we're trying to explain what this statute means, and the Court of Appeals certified a question that just doesn't say what is 16.064A. Does it apply? It asks if 16.064 applies.
And if it's not gamesmanship, why did not the party just comply with the order?
Your Honor, I have stated and restated in the filings, it was just a misunderstanding, a misappreciation. I don't know what to say beyond that. But the statute doesn't somehow write itself to read that if the lawyer is failing in some way that's not gamesmanship, that is subsection B, that somehow it wouldn't apply. And in fact, we have tons of cases in which the lawyers were heavily criticized. Integrity Global from Austin Court of Appeals in 2019. The lawyer in that case, and I believe he was representing Dell Computer. So we can all assume someone who is of great quality as advocate and counsel failed to properly invoke jurisdiction and had to enjoy the benefit of the saving statute to allow his case to proceed. And the court, in the opinion, criticized that attorney. In much the same way I'm certainly hearing this now. And yet, the saving statute saves.
So if here the district court judge had entered an order that expressly stated that he was dismissing based on the lawyer's failure to adequately plead a jurisdictional basis and therefore dismissing with prejudice under Rule 41B, if that was all spelled out in the order, then you agree that 16064A would not apply?
It wouldn't, because the court's inherent authority exercised at that moment would, to carry the analogy further, be a crucifixion. I would be over.
All the facts are identical except what words go into the dismissal order would govern that, even though the basis for dismissal is factually the same.
Because, Your Honor, that without prejudice carries great weight when we are assessing whether it's a sanction or not, and the due process that attaches when a sua sponte order is issued as a sanction.
Well, it's not just that it's with or without prejudice, it's that it's because of a lack of jurisdiction, and the federal court order says that, right?
Yes.
So, are we supposed to second guess what the final federal court determination is of whether the action is dismissed because of a lack of jurisdiction? Maybe it's final in the district court if there's no appeal. Maybe it's final in the Fifth Circuit if there's an appeal. But does this statute require us to go behind the face of the federal court order and decide as a state court if they were right or not about federal court jurisdiction and what they said about why they were dismissing?
If I could have brought you a cleaner mess, I would have. But thankfully, we only have the two questions as certified. So we look at the question certified and answered. And in my view, the statute does not create any kind of wrong court requirement. And in fact, and I'll point this
So
out.
your view is just, we look at the face of the trial court's, the federal district court's order, and it says what it says, and it says dismissed because of lack of jurisdiction, and that's all we need, unless there's an allegation of intentional disregard.
Yes, Your Honor, and the statute specifically spells out what must be invoked in order for intentional disregard to be a claim as part of it's an abatement. You have to move for it. And I'm about to run out of time, but very quickly, if it please the court, I would just say that the statute withdrew from the caption wrong court, and I think the briefing goes over that. I mean, this is a very old statute, and that wrong court caption is from the 1930s. It was removed in the 70s as part of anything related to the statute when it got modified to be 16064. And at the time of removal, very shortly thereafter, we get the Government Code, Chapter 311, that tells us we could consider captions if there's a question as to the application of the statute. But here, the legislature specifically removed the reference to wrong court. And I reserve the remainder of my time. Thank you.
Any other questions? Thank you, Mr. Davis. We'll hear from the respondents. Or the appellees, actually.
May it please the court, Mr. Knight and Mr. Sanfilippo will present argument for the appellees. Mr. Knight will open with the first 12 minutes.
May it please the court. Section 1664 provides for short-term tolling for plaintiffs who file their claims in a wrong court. It does not provide years of tolling to save claims that are improperly pleaded in a proper court. The court should answer no to each certified question. As to the first question, the statute's text aligns with how this court has always described 1664, according to its history and purpose as a wrong court provision. As to the second question, the statute provides a limited window for refiling after the initial jurisdictional dismissal. It does not extend limitations until after all appellate remedies are exhausted. So turning to the first question, the question is whether 1664 applies when plaintiffs first file in a proper court but simply fail to plead their claims to invoke that court's jurisdiction.
Well, all the statute says, and it's a little bit strangely constructed because of the comma, but if you sort of realign the parts of the sentence, it says the action is dismissed because of lack of jurisdiction. Shouldn't we just look to the face of what the federal district court said about why it was dismissing, and if it says it's because of lack of jurisdiction, then it's because of lack of jurisdiction?
Well, two responses to that, Justice Busby. First is the statute's referring to a dismissal when the court is not a court of proper jurisdiction. So if we look to the context of that because of lack of jurisdiction, the statute is in subsection A is describing the first court as one where there's a lack of jurisdiction, and the second different court as one that's a court of proper jurisdiction. How these are juxtaposed with each other.
Well, if there's a lack of jurisdiction, then it's not a court of proper jurisdiction.
Well, that in a sense that's right, but the context, how these terms are intentionally used to be focused on the courts, not the claims being pled. So not is it the claim invoking the court's jurisdiction, it's focusing on the courts, and that's consistent also with the history and purpose of the statute. This original title was as a wrong court provision, an act to extend limitations because of the filing of any action in the wrong court. And that was shortened in a non-substantive recodification to what it is now in 1985, but that was expressly non-substantive, and it shows what dismissal for lack of jurisdiction was supposed to be effectuated.
Your clients acquiesce in the finding of lack of jurisdiction by not, at the time of dismissal, saying, hold on, we want to be in federal court. There is diversity. Don't dismiss based on lack of jurisdiction. There wasn't anything like that until after it was back in state court, and then the statute runs, and then all of a sudden, oh, wait a minute, this is supposed to be in federal court. It's a little bit of what the statute was probably trying to get at, which is that substantive rights shouldn't be lost because the parties are in disagreement about where the merits of the case ought to be adjudicated.
Well, Your Honor, that's right. Nobody disputed diversity jurisdiction in the first case. We didn't raise our hand and say, in fact, there is diversity jurisdiction.
But in fact, you think there is, because we're in federal court again, except now you're here, which I realize you didn't want to be here, but.
No, in fact, we do think there is diversity jurisdiction. It's undisputed that, and I want to make this point, is it's undisputed that Northern District was a court of proper jurisdiction, that it did have jurisdiction, that there is diversity jurisdiction in this
Well,
case.
if it wasn't properly invoked, if you had gone through and gotten a final judgment and went to the Fifth Circuit, it would have been reversed for lack of jurisdiction, would it not?
That's correct. It wasn't properly invoked. But that's kind of the point, is that the statute is not meant to deal with pleading defects. Its text talks about, I'll go back to the text a little bit in subsection A, because I think this is important, that it's juxtaposing the court where there's a lack of jurisdiction and where there's a court of proper jurisdiction. And this does two things.
But to say that a statute that's concerned with whether there's jurisdiction isn't concerned with pleading defects strikes me as a strange. I'm not sure how that could be, because we determine jurisdiction from the pleadings, don't we? And as Justice Young said, there's no jurisdiction unless pleading successfully invokes it.
Well, the statute is talking about whether the court is a court of proper jurisdiction, in fact, and here
that's a concept that I struggle, that I'm not familiar with. The notion that there's just sort of abstractly jurisdiction over the situation, irrespective of what's been pleaded. That seems to go against the notion that we look at the facts as alleged in the pleading to determine whether there is jurisdiction.
Well, certainly, Justice Blacklock, the pleadings are how we get to determining the jurisdiction, and they're talking about that this is meant to save their situation where they fail to adequately plead. But the remedy when you fail to adequately plead your claim is to amend your pleadings.
But now that you want to be in federal court, you're confirming that jurisdiction exists. Couldn't you have pleaded in your pleadings? Diversity jurisdiction exists. Our clients are diverse, completely diverse from the plaintiffs. Therefore, there is federal jurisdiction. But instead, you acquiesce to the dismissal for jurisdictional defects, only to later then invoke the legal statute and urge federal court jurisdiction yourselves. And you see what's played out in this case seems to be what the saving statute addresses, which is we're going to let people ferret out where jurisdiction should lie, but it is not going to affect limitations while they sort this out.
Well, Your Honor, it's correct. We did not. We didn't say in our pleading in the district court that the court in fact has jurisdiction. We did suggest to the Fifth Circuit that Judge Starr was like to the proper jurisdiction, that it appeared that all parties were fully diverse. But that is not what this statute is actually supposed to be addressing.
You didn't oppose remand to state court, is what I'm saying. In the initial series of procedural maneuvers.
No, we didn't. I think we stayed silent as far as we know. But that's not what this statute is supposed to be addressing. The statute is addressing the scenario when plaintiff files in a court that actually doesn't have jurisdiction, and they get down the road a little bit, and the court tells them, hey, this is the wrong court, you filed in the wrong court, and then it gives them time to go file in the right court if limitations has run in that first case.
Where I'm getting hung up on your argument is the actually part, because the statute doesn't say actually have jurisdiction. And so I guess my concern with the approach that you're advocating, and maybe you can help me with this, is it seems like it creates a difficult and expensive and hard to predict way of applying this statute, because you never know. I mean, the federal district court may say the action is dismissed because of lack of jurisdiction, but it may turn out, you can't rely on that because, a good lawyer may be able to say, well, there was jurisdiction all along, and in fact, we think so much that we're going to remove the case to federal court. So I'm just trying to figure out what in the statute, other than B, where the legislature spells out in this circumstance you go behind the court's finding, and if there's intentional disregard, that's one circumstance where they say you do look behind what the federal court said, or whatever court is dismissing for lack of jurisdiction. Why should we look behind what the court said in other circumstances that are not intentional disregard to see if it's because of lack of jurisdiction?
Just as we, I think the answer is that normally we're not going to be having to look behind the court order. This is a wrong court provision, and the judge says that we have there's a pleading defect here. The statute doesn't apply, we have a pleading defect. You haven't adequately alleged jurisdiction. In that scenario, the remedy is to amend the claim, and that's going to be on the face of the order as well. And so we're not having to look behind that to determine whether that court is a proper court. And any other determination wouldn't be conflicting with that either, because there was no determination up or down on jurisdiction either way. It was just saying, you haven't adequately pleaded your jurisdiction.
But doesn't that equate to meaning that you don't have jurisdiction? That there's a lack of jurisdiction when you don't plead it?
Well, ultimately, that's correct. It does not mean, however, that the first court is not a court of proper jurisdiction, which I think is what the statute is really concerned about. And I think a helpful formulation for this is how this court described 1664 in the city of DeSoto versus White. It said the statute applies when the party files in one court and jurisdiction is only proper in another. That gives meaning to both A and B, or A1 and A2. And it's a really easy rule to apply, because if there's
The danger of paraphrasing statutes, isn't it?
Well, the paraphrase was a really good paraphrase, Justice Blacklock. I think it exactly tracks A1 and A2.
Which would surely apply there, but does it only apply there?
I think that's the most natural reading of how A1 and A2 go together, and also how subsection B fits with A1 and A2 when it talks about the statute doesn't apply if you file with intentional disregard of proper jurisdiction. It'd be difficult to file with intentional disregard of proper jurisdiction if you're filing in a court of proper jurisdiction. So the fit is much better.
Why could not have happened in this exact case? I know you have affirmatively waived this argument, I think, but when you have a district judge saying, in order to invoke jurisdiction, converting it from potential jurisdiction to proper, actual jurisdiction, and someone files something that is objectively does not do what the order objectively said to do, why would that not be what subsection B is talking about?
Well, I think that'd be reading subsection B in 1664 broadly as a broad savings provision rather than the one that's focused on the courts in which the action is filed. In that scenario, the remedy is to replete your claims, to adequately plead your claims. In this case, Judge Starr gave plaintiffs an opportunity, and he told them exactly how to replete their claims, and they didn't do so. They sought reconsideration. They didn't appeal that reconsideration. The Fifth Circuit said that would have made a difference. So I think plaintiff's complaint here is really with a perceived inequity in the federal courts. The court shouldn't read Texas's limited savings statute.
I don't understand the answer as to why isn't intentional disregard of proper jurisdiction to file something that, to intentionally file something that disregards what the court said is required to invoke jurisdiction.
I think if the court reads the statute broadly, more broadly than we are advocating for.
I mean, so you're saying that that's an alternative argument?
Yeah, sure, yes.
If a suit is filed initially in federal district court and the defendant asserts limitations as a defense, so there's no removal like there was here for the second filing, but initially filed in federal district court and the defendant asserts limitations, can a plaintiff rely on 16.064 in federal court in the absence of removal? I'm trying to get into the question of why 16.064 applies here. Is it because the second suit was initially filed in state court and then removed?
As a procedural.
Not a substantive law. Why is the federal court even care?
That hasn't been talked about at all in this case thus far. That has not been raised.
Is it because we're using the state statute of limitations?
I think that's exactly why. And federal courts deal with 1664 with some regularity.
So long as it's a state substantive limitations,
That's right.
then this procedural tolling provision will apply in the federal courts.
That's right.
Okay.
I just have one last quick question about B. So I sort of interrupted you. You were about, I think, to tell us more about why, even though B, you haven't argued that it applies of its own force here, it gives us some structural or textual clue for us to read A in the way that you want. Could you tell me a little bit more about that?
Yes. So B says that the statute doesn't apply if the filing is made with intentional disregard of proper jurisdiction. Proper jurisdiction is used in both B and A. And in subsection A, they're describing the court's jurisdictional limits. And so in subsection B, I think it makes sense to give it that same reading, given the proximity in the statute and how we normally construe terms consistently. And again, it doesn't make sense that you could file with intentional, and I know that you disagree with that, but you can file with intentional disregard of proper jurisdiction if you're in a court of proper jurisdiction. So we ask the court, I see my time's expired. Unless the court has any other questions, I'm going to ask the court to answer no and both certified questions. Thank you.
Any other questions? Thank you, Mr. Knight. We'll hear from Jim.
May it please the court. Unless the court would prefer otherwise, I'd actually like to start with the second certified question. Second certified question asks this court to decide whether plaintiffs filed this lawsuit within 60 days of the date that the prior judgment became final for purposes of Texas Civil Practice and Remedies Code section 16.604A2. This question must be answered no unless this court finds that a dismissal in the district court is not final until not only it's affirmed on appeal, but also after all petitions for rehearing have been denied.
Isn't that normally what final means?
That's not always what final means. Final ordinarily means when there's nothing left to do, when the judgment's signed by the district court, and there's nothing left for the court to do other than to carry out the judgment.
So why wouldn't the legislature have said that if that's what they meant?
I think if you look at the language of the statute, that is sort of what they intended. When you look at it, it says when it applies either from the 60th day after the date of dismissal or other disposition. So they're talking about it either runs from 60 days if it's dismissed in the district court, or it runs from the date that the first jurisdictional dismissal is on appeal.
Well, it says after the date that the dismissal becomes final. So not after the date of dismissal.
But the dismissal becomes final. We would submit it becomes final when it's signed and entered in the district court, regardless of whether there's an appeal. But if you're going to take a liberal view of that language, then we would say it becomes final when the district court loses power to alter the judgment. In either scenario, of course, the filing would have been too late here in the statute. The claims would still be on time.
So if I understand you, you're suggesting the way to proceed is after the dismissal. You think it's wrong, you bring your appeal, but you nonetheless have to file a new suit in a different court. So that's going on. You're getting started with that. I suppose you could ask the court to abate and delay it, but you've got a whole new thing. So then if the Court of Appeals says, oh no, there was jurisdiction all along, what do you do to the second one? You dismiss that one, you go back to the first.
We actually do think that would have been the most efficient way to proceed. I think, frankly, that this case is a poster child for why that would be the most efficient way to proceed.
So would there be any real reason to have the appeal at that point? I mean, now you're in a court, and the other side acknowledges, okay, fine, you've met the savings statute. Here we are in a court of clearly proper jurisdiction. What's really the point of continuing with that appeal?
The point would be if you really wanted to bring your case in the Northern District of Texas instead of the Southern District of Texas.
And in this case, it's been brought in every court in Texas at this point, I guess. So
It seems like that. But as this court has recognized, and I believe it was the Levinson case, it is actually caution practitioners that the use of protective suits is actually an efficient way to avoid these long protracted fights over whether or not jurisdiction, or whether or not limitations should be told or bars claims. And I mean, this is a poster child case for that.
Of course, that was absent a statute that specifically authorized savings, so we were being very hesitant to extend things just of our own authority. Here we have a statute that uses final that could mean one of two things.
But we believe our interpretation not only affects the intent of what the saving statute was supposed to provide, but it also does so without undermining the purpose of statutes of limitations. The intent of the saving statute was to provide a short window, a 60-day total period. If you give that finality, if you give that a liberal construction, appellants would have had 116 days from the date of the original dismissal order to file another lawsuit. I believe that keeps it in with the intent of a short window. If you run it all the way out until beyond bonk is denied, that jumps to 463 days of total.
If you file a second suit and the second judge abates it because that judge says, well, I have an appeal pending, maybe it's going to actually be proper where the plaintiff originally wanted to go, so I'm not going to waste my court's time and start doing a whole bunch of stuff. How does that actually amount to a savings?
Worst case scenario, that would have saved us at least 2 years because the first
Court of Appeals
first dismissal was affirmed, I believe it was in September 2021 was when the denial was, the bond was denied. We're sitting here in 2023.
But you're assuming that if it had been refiled, that judge would have said, well, I'm not going to abate. But you would have opposed abatement?
Either or, we think, I can't tell you that we would have opposed abatement, but either or, I think it's a time savings.
Well, what really would have saved you time is to agree that there was federal court jurisdiction to begin with, right?
What would have saved us time is if the order would have been followed and it would have been pled in the Northern District.
But you could have pled it too.
Theoretically, we could have.
Well, in fact, is it not true that all parties in federal court are obligated to alert the federal court to defects in jurisdiction or potential defects in jurisdiction?
I think that's probably true if there's a defect in jurisdiction.
So you think that
Judge there was a defect in jurisdiction?
Well, there was. If federal jurisdiction does not exist until it's properly invoked, and we know that it was at the mid-camp case and some of the other recent ones where it goes all the way through and the federal court says no jurisdiction until it's properly invoked, which is to say that all parties have to tell the judge, and one thing they could do is to say, I have to alert you, you don't have a proper invocation, but for our part, we can say we're citizens of this state, our place of incorporation is that state, our place of business is that state, because all that there has to be is in the record, the proper invocation of jurisdiction. And that didn't happen, right?
It did not happen, and to be candid, I don't think any party even thought about it until the judge raised it sua sponte. And once he did, and he issued his order and said, here's how you fix it, I don't think there was anything else for us to do. The order couldn't have been any clearer on how you fix it, and it just wasn't fixed. And
you're relying on the concept of finality in the judgment that we use often to determine whether a judgment is appealable. Is a trial court's judgment final and appealable? Is it final in that it resolves all parties and claims and leaves nothing else to be determined? So, and when we look at that, like for example, we talk about a court's continuing jurisdiction after entering an order, and the trial court loses jurisdiction 30 days after entering an order if the order was final, right? If it dismissed the action, to use the language here, to the extent that it was final. And I get that you're using it, I mean, that's a very legitimate understanding of the meaning of the word final when referring to a trial court order. But the statute refers to that very order becoming final. And yet, under the concept that you use the word, which is a valid concept, it is final at the moment of entry if it's a final order under the definition. So how can it ever become final if it's final at the moment of entry?
And that's why when I used the example of the number of days they had to refile, I took it from the date that the court will have lost jurisdiction.
Yeah, but it doesn't lose jurisdiction unless the order is final. If the order is entered on January 1, and we're wondering whether the court lost jurisdiction on January 31st, to make that decision, we have to look to see whether the order was on January 1, was a final order. It didn't become final on January 31, the court lost jurisdiction, only if it was final on January 1st.
May I respond? Yes. Thank you. That's why we think that the date should run from the date that the district court or trial court loses the power to alter that judgment, which is going to be 30 days at a minimum from the time that it's actually signed or entered. And if there's post-judgment motions, then it's going to be either when plenary power expires or when the last motion is decided. And then, frankly, that's a liberal reading of the rule to us. And that's the
Somebody appeals a judgment, it has to be final. So if they appeal before January 31st, in Justice Boyd's hypothetical, we would never say, oh, well, that was a premature. We have ways to deal with premature notice of appeal, but the notice of appeal would not be premature just because plenary power hasn't run. You can appeal immediately, right? So it's final. So you're kind of picking a point in between the two definitions of final, seems to me.
We think that we're picking the most liberal version that ends with what the legislature intended, which is its final one, the court that actually issues the dismissal order. And sometimes that's on appeal, but whatever court issues that dismissal order should be final when they lose the power to alter it.
Are the Northern District and the Southern District different courts for purposes of A? I know this was filed in the state court, which is a different court. If it had not been, would those be two different courts?
I believe the Northern District and the Southern District are considered two different courts.
For purposes of this?
We do.
Any other questions? Thank you, Counsel.
Thank you, Your Honors.
Mr. Davis, you have 5 minutes.
Just briefly, 2 points. Actual is not in the statute. Wrong is not in the statute. Only is not in the statute.
Wrong was in the title, and it was a non-substantive codification, but that's not something that's improper to consider. That's not legislative history. That's the history of the statute.
Actually, it's not the history of the statute because it wasn't in the statute. And under Chapter 311, they specifically prohibit that kind of reflection. Interlineation, which is what that is, striking out on the revision, means discarding the thought with respect to wrong. It's not required. And so here, in this particular instance, when we read the statute as written, the period between the date of filing and action in a trial court and the date of a second filing of the same action in a different court, there's no regard to wrong or only. There's no regard to actual in the second provision because of lack, not even a lack, because of lack of jurisdiction. The trial court where the action was first filed, reflecting on subsection A, and the action was dismissed. So when we read it as read, I don't see how we make the logical leaps appellees argue for with respect to wrong. We pursued the claim, and I guess this goes back to what is the statutory purpose of statute of limitations and the savings statute? Well, it's to ensure due process protected, both for the litigants seeking their claims and for the defendants. The statute of limitations benefits the plaintiffs because they don't have to argue about whether or not they brought it timely if they bring it within 2 years. It's a benefit. It's clarity. The statute of limitations is also a great benefit to defendants because they know they're off the hook after that time frame, or they should be, typically are. Good. Due process for both sides. The savings statute, likewise. Due process, but how? It ensures that when the plaintiffs properly seek and timely seek their claims against the right defendants and just get the jurisdiction wrong for whatever reason, they are not barred from having it be figured out.
Can that be connected over and over? I mean, if you, yet again, were to have filed in a court of improper jurisdiction and subsection B was not invoked, would you be able to say, well, okay, let me try it again. And then that way, we'll move across the state or something. Is that
Thankfully,
proper or not?
Thankfully, that is not this case.
But my question is, does the statute allow that in your view or not?
I have no idea. I could probably
Well,
address it.
very technical about the words of the statute. Does the word first and second play any particular role? Because this is now the 4th filing, is it not?
Well, no, I mean, to the extent that we're talking about petitions filed, I'll put it this way. In Texas, state court, I can file a non-suit as many times as I want.
And maybe the savings statute says we're going to give you this special benefit for one mistake.
It doesn't say that.
It says first and second.
Well, it says.
I think you're probably right, but I'm just wondering if we're going to be very, very, very technical about it. We're taking with great exactitude what the words say and don't say. Well, they say that.
I think that when we talk about first filed, it's reflecting back on the lack of jurisdiction. And in this particular case, the lack of jurisdiction stemmed from the Northern District filing and then the Fifth Circuit's upholding or affirming that in their memorandum.
I think that's probably right, but I then also wonder if there isn't some merit to the other side's point that the structure of this statute is, despite using language that if we insist upon reading your way we could, is really getting at the situation that Justice Bland started with near the beginning of this argument.
Not being the case before the court, I don't know that I have a qualified opinion to offer, Your Honor.
But that's our job is to give an opinion on the statute. We also don't have any particular interest in this case. It's not our case. It's a federal case. The Fifth Circuit gets to do it once. We just have to give it some advice that the Constitution of our state now allows us to do.
Well, and I would just respectfully suggest if we have a saving statute, and if it can be properly read, and I believe that it can, and applied to this case to save the case, because their due process rights on the issue of statute of limitations are not offended. They have been litigating with us for years, as much as it's been many, many days between one filing and the next.
So is that, to make sure I'm understanding, you're saying that if there is sort of an equipoise, the thumb should be in favor of preserving a claim, litigate on the merits. Is that what you're saying?
The legislature says it. The legislature says it. Right here in 16064. That's what they have told us. And if they wanted to say something different, like wrong or actual or only, they certainly could have put that in there. They had it in the caption before, and they interlineated it. It does not apply. It's not to be considered. And so, yes, I'm absolutely saying that for the purpose of a saving statute to save, it must therefore save. And to the extent that judgments can be made, well, there is one area in which a judgment can be made, and the legislature said this is not applicable, and it's under subsection B when there's gamesmanship. Now, it's not present here. Plaintiffs affirmatively filed in federal court on purpose, seeking their tort claim under Texas law, but in federal court because we had a lot of work to do before limitations ran on a third-party out-of-state defendant. That's it.
Any other questions? Thank you, Mr. Davis. That concludes the argument in all cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable Supreme Court of Texas now stands adjourned.